Hello, we are reading Equal Justice Under Law, Thurgood Marshall today. This was written by Mara Rawcliffe, and we are going to get right into it, guys. I'm going to try to make this video as short as possible. So let's do this. At his school in Baltimore, Maryland in the early 1900s, Thurgood Marshall may have been one of the smartest boys in class, but he was not exactly well behaved. If he wasn't throwing chalk or teasing girls, he was arguing with teachers. So one day the principal sent him to the basement with a copy of the United States Constitution and stern orders not to come back up until he had memorized a passage. Before I left that school, Marshall said many years later, I knew the whole thing by heart, which goes to say that he was sent to the basement a lot. I don't know that that was a really good a way to punish someone or like a good way to do something about it, but okay. Anyway, parts of the Constitution, however, confused the young Marshall. For example, the 14th Amendment clearly stated that all Americans must be treated equally under the law. But growing up in Baltimore in the 1920s, Marshall knew that they were not. Like other southern states at the time, Maryland enforced, and Maryland is not a southern state, but I just want you to know that because it says like other southern states. Maryland is not a southern state, but like other southern states at the time, Maryland enforced a strict system of segregation. Everywhere, African Americans were kept apart on buses and trains, in restaurants, hotels, and schools. Anything from a water fountain to a movie theater or public park might have a sign saying whites only. Even the United States Supreme Court supported these unjust laws. In 1896, in the case of Plessy versus Ferguson, the court had ruled that segregation was allowed under the Constitution. The facilities for Black Americans, the court said, simply had to be as good as those for whites, separate but equal. In reality, separate almost never meant equal. For example, while Marshall earned high grades in college, the all white law school of the University of Maryland refused to admit him. Maryland had no law school for African Americans. So I'm going to try to keep this one short, try to keep it short. Determined to become, no, I feel like I got to say this anyway. The reason why this is important, Maryland had no law schools for African Americans. The point that they're making here is when you say that things are separate but equal, how can it be equal if there aren't even any opportunities for Black Americans to go to a law school unless they went to one that's all white? Well, then that means there's not an opportunity for Black Americans to be lawyers and judges and all those other things. If there's no opportunities for Black people to do these things, then when Black people are arrested, how are they able to get people that they know are going to support them, that they know are going to have their back, or that they can relate to? So it has a lot of effects when you don't have equal opportunity. That's all I'll say. Okay, keeping it short, keeping it short. Determined to become a lawyer anyway, he enrolled instead in Howard University in Washington, D.C., one of the few institutions that welcomed African Americans as students. Marshall left law school eager to win justice for his people. Back in Baltimore, he became known as the little man's lawyer, okay, often taking on cases without being paid. Soon, the National Association for the Advancement of Colored People, NAACP, excuse me, which this is not a phrase that we use, colored people. This is not a phrase that we use in 2022, but that is what that acronym stands for. But it is, what's the word I'm looking for? Not suggested. It is assumed. No, not assumed. It is understood that that is an insensitive and derogatory and rude phrase, colored people. So we don't use that. But the institution, the NAACP, was founded a really long time ago when the phrase colored people was a normal phrase, but we don't use that phrase anymore. Anyway, soon the NAACP asked him to join their legal team. He took charge, becoming known as Mr. Civil Rights. He helped organize a boycott of businesses that refused to hire African Americans. He successfully sued local school boards that paid Black teachers less than half as much as white teachers. He even won a case against the University of Maryland, and the result of the decision was that the university had to admit its first Black law student. In 1950, a group of African American parents can't read today. In 1950, a group of African American parents in Clarendon County, South Carolina, asked the NAACP for help. Schools in Clarendon County were separate and far from equal. White children rode buses to modern brick schools with libraries and playgrounds. Black children walked miles past the white schools to cramped, unheated wooden shacks without enough desks and chairs or even any bathrooms. The parents took the all-white school board to court, hoping to win a decent education for their children. But Marshall wanted more. He wanted to persuade the court that segregation was itself wrong, that the whole idea of separate but equal was fundamentally unjust. To show that segregation made Black children feel inferior, Marshall that's not the only problem with segregation is how a Black child feels. It also has to do with how it sets them up for their future, but we'll focus on this one thing. To show that segregation made Black children feel inferior, Marshall brought in a respected psychologist named Kenneth Clark. Clark described a simple test he had performed on more than 200 African American children in segregated schools. He showed each child 2 white dolls and 2 brown dolls. Then he asked which dolls they liked best. The children said the white dolls were nice and pretty. The brown dolls, they said, were ugly and dirty. When Clark asked one little girl which doll was most like her, she burst into tears. Despite Clark's dramatic testimony and other evidence that Marshall presented, the court ruled that Clarendon County could satisfy the law by spending money to improve Black schools. In other words, the court allowed the schools to remain separate and only required that the county spend more money to make them equal. According to this ruling, segregation was still legal. Marshall was disappointed, but he was not discouraged. He had a new plan: to take the fight against school segregation to the Supreme Court of the United States. Marshall and his team of lawyers began gathering cases. One was the Clarendon County case. Others came from Virginia, Kansas, Delaware, and Washington, D.C. The whole group of cases was known by the name of the first scheduled to be heard: Brown versus Board of Education of Topeka, Kansas. Marshall faced opposition even within the African American community. Some said that America was not ready for desegregation. If you challenge separate but equal, they said, we might lose even what we have already gained. Others supported Marshall. We want our rights now, not a century hence, they said. Marshall worked tirelessly on the case, hardly stopping to eat or sleep. Finally, on a cold December morning in 1952, Marshall stood looking up at the Supreme Court building. High above him, giant letters carved into the white marble spelled out "Equal Justice Under Law." On this cold day, he hoped he would help those words become reality. Hundreds of spectators, Black and white, crowded the steps. Inside, hundreds more jammed the halls leading to the packed courtroom. Marshall's opponent was a well-known lawyer named John W. Davis. Marshall greatly admired Davis. As a law student, he had sometimes skipped class to see Davis argue cases before the Supreme Court. Davis seemed unbeatable. Marshall repeated the argument he made in South Carolina. Segregation hurt Black children. There was no reason for it other than to keep one race up and the other down. African Americans were not receiving equal treatment under the law. Davis argued that since the case of Plessy versus Ferguson, the Supreme Court had upheld the idea of separate but equal. Segregation was a fact of Southern life. Why, asked Davis, would Black parents want their children in a school where they would be rejected or hated? How about they just not be rejected or hated? Anyway, in the South, Marshall responded, they had seen white and Black children walking down the road together. They separate and go to different schools, he said, and they come out and they play together. In other words, children did not choose segregation. They would learn to accept integrated schools. Davis remained confident. On his way out of the courtroom, he whispered to a colleague, I think we've got it won. An exhausted Marshall thought so too. As always, Davis had argued with great skill and poise, and the law was on his side. Marshall had little hope that the Supreme Court would admit that they had been wrong for so many years. But 6 months passed and no decision came. Instead, the court asked the lawyers on both sides for more information. What, they asked, was the original intent of the 14th Amendment of the Constitution? That amendment says, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deny to any person the equal protection of the laws. The Supreme Court wanted to know, does that language allow separation of the races? Does the court have the power to outlaw school segregation? It was a second chance. Marshall gathered 85 experts, historians, sociologists, educators, to help him prepare his answer. Week after week, they planned, talked, and argued together late into the night. At last, the day arrived. Marshall was ready. In a voice that boomed off the high ceiling of the crowded room, he made his case. Segregation, he argued, was unconstitutional. What reason could there be for separating the two races, he asked, unless the court found that for some reason Negroes are inferior to all other human beings? This is another word that we no longer use. However, they are quoting him at the time. Some people, including myself, believe that even when quoting someone, you should take out words that we no longer use. Other people say that to take out the words would mean to tarnish the original quote. So you may fall on one side of the argument, or maybe you fall in the middle and don't really care either way. But I do want to acknowledge that Negro is not a word that we use any longer. It hasn't been a word that we use in polite society in a long time, and it should not be used any longer. There are certain ways to refer to certain people, and Negro is not one of them. That's going to be the last time I say that word in this video. As he spoke, Marshall seemed to embody the very point he was arguing. He was knowledgeable, well-spoken, a brilliant lawyer, and African American. Clearly, race had nothing to do with intelligence. After the second round of arguments was finished, again the months dragged by with no decision from the court. Marshall went back to the road for the NAACP, trying to raise money to pay the organization's enormous legal bills. Then, one night in May, after a fundraiser in Mobile, Alabama, the phone rang. Marshall was scheduled to speak in Los Angeles the next day. Catch the next flight to Washington, D.C., the caller said. The Supreme Court is ready to announce its decision. By early afternoon of the next day, Marshall found himself seated, shifting nervously in the lawyers' section of the Supreme Court. Chief Justice Earl Warren began to read the court's opinion. It was long and detailed. He discussed the history of segregation. He gave the legal background. He talked about the importance of education. Which way had the court decided? Marshall couldn't tell. He stared at one of the justices, a Southerner. Marshall was sure he would fight for segregation. The justice stared back. This is Thurgood Marshall here, standing outside of the Supreme Court building in 1955. Here we go. All right, got one more page here. Finally, Chief Justice Warren got to the heart of the matter. Did sending Black children to separate schools, no matter how good those schools might be, deprive them of an equal opportunity for education? Warren concluded, we believe that it does. To separate some children from others for no reason but skin color, he went on, could affect their hearts and minds in a way unlikely to ever be undone. The decision was unanimous. All 9 justices agreed. Separate schools could never be equal. Segregation must go. Marshall said later, I was so happy I was numb. Over the course of his career in the NAACP, Thurgood Marshall argued 32 cases before the Supreme Court. He won all but 3. And in 1967, President Lyndon Johnson appointed him to the Supreme Court, where he served for 24 years. But to many, Brown versus Board of Education remained his greatest victory. A fellow Supreme Court justice said of Marshall, no American did more to lead our country out of the wilderness of segregation. Okay, that is the end, but I just have one thing to say, is that when we talk about segregation, often, in fact, almost all of our conversation is about white and Black people being segregated. And I just want to remind you all and remind all people that there were more than just Black and white people in America at this time. You had indigenous people, people that were indigenous to America, meaning Native American people. You had Mexican people. You had Latino people. You had Asian people. You had so many people from so many other places in the world that were here in America, also experiencing segregation. Maybe some of them weren't. In some places, Irish people were looked down on just as terribly as a person who was Black, and in some places they weren't. In some places in America, Jewish people were looked down on just as terribly, and in some places they weren't. So it's not an across the board, but I just want to remind us that there were more than just white and black people in America at this time experiencing these things, weighing in their opinions, things of that nature. So I just want to add that.